We are on the record by Zoom and calls number 2410472-20, State versus Antonio Tucker, who is present by Zoom. Calls number 241-0473-20, State versus Antonio Tucker, present by Zoom. 0472 is a charge of burglary of a habitation with intent to commit another felony. 0473-20 is impersonating a public servant as alleged in the indictment. Also over here in calls number 2410127-19 is a motion to revoke community supervision, State versus Antonio Tucker. We'll start by the numbers and just go back and do the motion to revoke community supervision first. And this is obviously the first case. The motion to revoke community supervision, that's calls number 2410127-20. Mr. Tucker, just raise your right hand. I've got to get you sworn in. Do you solemnly swear or affirm the testimony you'll give in the causes now on trial will be the truth, the whole truth, and nothing but the truth, so help you God, and that all the documents in all three cases that show they are signed and sworn to by you are signed and sworn to by you now, freely, intelligently, knowingly, and voluntarily?
Yes.
Can you speak up a little bit, Mr. Tucker?
Yes, sir.
All right. With Mr. Davis here on Zoom and Ms. Anderson, I'm just starting with the motion to revoke community supervision. Let's see, I'm going to have to end these. I don't know whether I'm going to get the y'all's plea agreement on this one. I don't seem to have. I'm going to have to get the plea papers on it, but let me go ahead and get this one done. It's cause number 2410127-20. 27-19. Mr. Tucker, have you gone over this motion to revoke community supervision with your attorney, Mr. Zach Davis, so you understand all the allegations in the state's motion to revoke community supervision?
I do.
All right. Now, you understand that originally in this cause number 2410127-19, you were charged with the offense of possession of a controlled substance less than a gram. Apparently, you were assessed a sentence of 2 years in the Texas Department of Corrections Institutional Division. I'm sorry, you were assessed 2 years in a state jail division. It was a state jail felony facility for the offense of possession of a controlled substance, a state jail felony. The court back at the time followed the plea agreement, the recommendation of the state, and assessed your sentence at 5 years deferred adjudicated probation. I'm sorry, 5 years. That must have been regular probation. I'm sorry, I'm not sure I have, or I may have misplaced them here on the bench. I don't know, but I don't seem to have the actual documents from that plea in front of me right now. Anyway, we'll do the best we can. The motion to revoke community supervision, that alleges violations of your probation. Do you understand that, Mr. Tucker?
I do.
And it alleges violation in all the paragraphs. Have you gone over the motion with Mr. Zach Davis, your attorney? Because it alleges there's 7 paragraphs in it. 6 of those 7, in fact, 8 of them allege violations of your deferred adjudicated probation. Do you understand that?
Yes, I do.
All right. Now, do you understand that if you do stipulate and enter pleas of truth to the allegations in the state's motion to revoke your probation, obviously the court is going to find those allegations true, and then you can be, on this case, assessed a sentence of up to 2 years in a state jail facility and a fine of up to $10,000. Do you understand that?
Yes, sir.
All right, your original, hang on.
What are you looking for?
I'm going to go off Zoom just a minute. I don't seem to be able to understand. All right, we're continuing on the record in cause number 2410127-19, State versus Antonio Tucker, on the state's motion to revoke community supervision. So to get down to where my next question, Mr. Tucker, was going to be, have you gone over the state's motion to revoke community supervision with your attorney, Mr. Zach Davis, so you understand all the allegations being made against you by the state in its motion to revoke community supervision? Those are allegations that allege violations of your probation. Do you understand all those allegations?
Yes, sir.
All right, now I've got a document here from you. It's marked as States 5, now signed and sworn to by you. It's the written plea, admonishments, and stipulations of evidence. It's up there on the screen. It shows the original criminal charge of state jail felony, that if then it shows the maximum you can receive if the court grants the state's motion to revoke your probation. You can receive up to 2 years in a state jail facility, fine of up to $10,000. That document is signed by Mr. Davis. It's also signed by Antonio Tucker. You understand you've now signed and sworn to this document?
Yes, sir.
All right, up at the top, there's 4 admonishments, 1, 2, 3, and 4. Do you understand those 4 admonishments?
Yes.
Below the 4 admonishments, this is the stipulation portion of the document. You tell me that you fully understand and have read the foregoing admonishments, that's 1 through 4, as well as all the allegations against you in the state's motion to revoke your probation. Then you say, understanding the admonishments and the allegations against you, you say you make the following knowing, intelligent, voluntary stipulations of evidence. 1, you're obviously the same individual I placed on probation. 2, you're stipulating and telling the court under oath that the allegations as set out in all the paragraphs of the state's motion to revoke your community supervision are true, and that you are stipulating and entering pleas of true to all the allegations and all the paragraphs of the state's motion to revoke your probation. Is that correct?
That's correct.
The document, States 5, that you've signed and sworn to, you do understand that's a written judicial stipulation, admission by you to all the allegations alleged by the state, and you have signed and now sworn to that document. You've been over it with Mr. Davis. Is that correct?
Yes, sir.
All right, Ms. Anderson, you want to offer States 5?
We do, Your Honor. We offer States 5, the signed plea paper and admonishments.
No objection, Judge.
With no objection, the court admits into evidence State's Exhibit number 5, the written plea, admonishments, and stipulations of evidence containing the defendant's stipulated and entered pleas of true to all the allegations in the state's motion to revoke community supervision. The court admitting into evidence States 5 with no objection. The court finding all the allegations in the state's motion to revoke community supervision alleging violations of probation by the defendant are true. The court grants the state's motion to revoke community supervision. The court does find the defendant guilty in this cause number of the offense of possession of a controlled substance, a state jail felony, as alleged in the indictment. And the court, following the plea agreement, what was your recommendation on this, Ms. Anderson? I'm sorry.
Your Honor, we recommend 6 months in light of the fact that he'll be pleading to 2 additional new felonies today.
The court is correct, Mr. Davis.
That's correct, Judge.
The court in this case, then, having found the allegations in the state's motion to revoke community supervision to be true, the court having granted the state's motion to revoke community supervision, the court does find the defendant guilty of the offense of state jail felony, possession of a controlled substance, in cause number 2410127-19. And the court, following the agreement, having found the defendant guilty of the offense of state jail felony, possession of a controlled substance, the court assesses the sentence of 6 months in a state jail facility, assessed with credit for time served, restitution order to the Department of Public Safety in the amount of $180, credit for time served granted in a legal, reasonable, or formal sentencing. Mr. Davis.
No reasonable,
Finding
Judge.
none, formal sentencing is pronounced. The court does find the defendant guilty in cause number 2410127-19 of the offense of possession of controlled substance, state jail felony. Assesses the sentence at 6 months, 180 days in a state jail facility with credit for time served, restitution order to the Department of Public Safety in the amount of $180. You are.
Your Honor. I'm sorry to interrupt. He has paid $50 of that DPS reimbursement, and so his current balance that is owed to DPS is only $130.
The balance of $130 for the lab fee analysis is still large. Sentence is formally pronounced by the court finding the defendant guilty of the offense of possession of controlled substance, state jail felony as alleged in the indictment, having granted the state's motion to revoke probation. Formal sentencing is pronounced at 6 months in a state jail facility with credit for time served. Restitution ordered and stated into the record by Ms. Anderson, the balance due. Mr. Tucker, I have from you a waiver of appeal signed by you and signed by Mr. Zach Davis, your attorney. Do you wish to waive your right to appeal in this revocation?
Yes.
Court receives and accepts your waiver of appeal, or is it filed in the papers of the cause? Court formally pronounces sentence in this cause number at 6 months in a state jail facility, 180 days, with credit for time served. Restitution ordered, balance of the lab fee, which has been stated into the record by Ms. Anderson. All right, the waiver of appeals accepted. That one having been taken care of, we'll move on over to the other two.
And Your Honor, I'm going to need to make some amendments and then abandon a couple of paragraphs on both of these indictments.
Okay, let me catch up with you there just a minute, Ms. Anderson.
No problem, Your Honor.
All right, I've got copies here now of the indictments in 241-0472-20. Go ahead with your motions to amend on that one, Ms. Anderson.
Okay. Well, first of all, Your Honor, in both of these, I want the court to know that while I'm going to read into the record and make the motions to change the indictments, the actual language on the stipulation of evidence that the defendant signed and swore to has already been amended, and it already is correct on both of those. But just for the record, in cause number 241-0472-20, we would move to amend the indictment at the end of the first paragraph. We would change and strike the felony offense of aggravated assault with deadly weapon and replace it with simply the offense of assault. And we would also abandon the second paragraph, which is the deadly weapon language. The effect of this will be to charge it as a burglary of a habitation, second degree, enhanced to a first degree, with the enhancement paragraph at the bottom. And then on the second, yes, sir.
Sorry, Ms. Anderson, let me catch back up with you. So just to be sure I've got it correct, I know you said it correct, to be sure I've got it down. The amendment, state's amendment to the first paragraph is to have it read, the owner thereof and attempted to commit or committed the offense of assault. Is that correct?
Yes, Your Honor, that is correct.
And was there a second change?
Yes, sir. We're abandoning completely the second paragraph, which is the deadly weapon language.
State's motion then to amend the first paragraph is granted so that the allegations in the first paragraph of the indictment now read, and attempted to commit or committed the offense of assault. Second paragraph, which alleged the use of a deadly weapon, that is abandoned by the state on the state's motion. So those two motions to change the indictment in 241-0472-20 to how the court just stated in the record it now reads, those motions are granted. Now, were there changes over in 241-0473-20?
Yes, sir. There are. The state would move in the first paragraph. We want to abandon 6 words. In the last line of the first paragraph, we would strike the words pointing a firearm at Whit Bates.
The state's motion to abandon the language which now alleges pointing a firearm at Whit Bates with no objection, I'm sure, Mr. Davis, that state's motion is granted.
And we would also move to abandon the second paragraph, which is the deadly weapon language, also in this indictment.
State's motion to abandon the allegation of the use of a deadly weapon as alleged in the second paragraph. State's motion to abandon that paragraph is granted by the court.
So, Your Honor, now we have a burglary of a habitation enhanced to a first degree 5 to 99. And we have an impersonation of public servant, third degree, enhanced to a second degree, and there's no deadly weapon language on either offense.
All right, correct, Mr. Davis?
That is correct, Your Honor.
All right, then we'll go through, first of all, cause number 2410472-20. The court having granted those amendments to the indictment now contains in the first paragraph of the indictment the allegation that Antonio Tucker did that in there intentionally and knowingly enter a habitation without the effective consent of Whit Bates, the owner thereof, and attempted to commit or committed the offense of assault. The second paragraph is abandoned. Correct, Mr. Davis?
That's correct, Your Honor.
Do you understand those changes, Mr. Tucker?
I do.
Over in that leaves us with state to the court again, just for the record, Ms. Anderson, what the result of that was.
The result of that is it's a second degree burglary of a habitation charge enhanced to a first degree with the prior conviction alleged in the final paragraph. So making the sentencing range on that offense 5 to 99.
Do you understand that, Mr. Tucker?
I do.
Is that correct, Mr. Davis?
That is, Judge, and for the record, I think Ms. Anderson already stated this, but the plea paperwork that we've submitted to the court reflects both the changes that the state has made to the indictment, as well as the changes to the punishment ranges that coincide with that.
That's true, Your Honor. We prepared new plea paperwork reflecting all of these changes for the defendant to go over with Mr. Davis and be clear on the changes that we intended to move and make in court today.
All right, thank you, Ms. Anderson. All right, now, Mr. Davis, you've gone over all these changes in the plea papers with Antonio Tucker, is that correct?
That's correct, Your Honor.
Mr. Tucker, do you understand, I've sworn you in, do you understand all the changes in these plea documents, which are reflected actually on the plea documents that you signed and swore to in both cases?
Yes.
All right, so if we're starting on the pleas in cause number 2410472-20, this plea document is up on the screen. And first of all, if you look, the charge, of course, in the indictment is burglary of a habitation. One of the changes in that document on the burglary of a habitation, or the plea papers, is that you now have a plea agreement that if you enter a plea of guilty to the offense of burglary of a habitation, now alleged as a second degree felony, and that it's enhanced up to a first degree felony once I read these allegations to you from the last paragraph. So the first paragraph of 047220 charges you with the offense of burglary of a habitation, carries a sentencing range of not less than 2, no more than 20 years in the Texas Department of Corrections, fine of up to $10,000. Do you understand that?
Yes.
Now, the last paragraph of the indictment in 0472-20 alleges you have a prior felony conviction for the offense of burglary of habitation. I'm going to read those allegations to you and ask you whether or not your plea is true or not true. If you enter a plea of true to these allegations, it will increase your sentencing range from a second degree up to a first degree felony. So your full sentencing range on this offense is charged in 2410472-20, burglary of a habitation with intent to commit another felony. That has been changed now. So the full sentencing range you're looking at is, if you plead true to the allegations of the prior felony conviction of burglary of habitation, it increases your sentencing range from not less than 5 years, nor more than 99 years or life in the Texas Department of Corrections Institutional Division. Fine may be assessed at up to $10,000. Do you understand those changes on this one, Mr. Tucker?
Yes.
All right, looking at the plea documents now, to go over the plea documents, and the plea documents now reflect all this, which makes it a lot easier, Mr. Tucker. But your plea document in cause, and they're going to be going up on the screen. Your plea document in 2410472-20 burglary of a habitation now being charged in the indictment and enhanced to a first-degree felony. If you enter a plea of guilty to the indictment as it now stands, the state, Ms. Anderson, is recommending your sentence at 20 years in the Texas Department of Corrections Institutional Division, which will be assessed with credit for time served. Is that your plea agreement on that one?
Yes.
All right, over in cause number 241-0472-20, as you see there on your agreed punishment recommendation for that one, if you do enter a plea of guilty to that indictment, do you have a plea agreement there that the state will recommend your sentence and the court will follow the recommendation? It's also at 20 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. The court will follow the recommendation, assess your sentence at 20 years in the Texas Department of Corrections Institutional Division with credit for time served. It will be ordered to run concurrent or at the same time with the other 20-year sentence for burglary of a habitation. So bottom line is, if you plead guilty to the indictments in each cause number and the court follows the plea agreement in each cause number, you'll be assessed a sentence of 20 years in the Texas Department of Corrections Institutional Division to run concurrent at the same time with the other sentence with credit for time served. Are those your plea agreements, Mr. Tucker?
Yes.
Is that it, Mr. Davis?
It is, Your Honor.
Those are your recommendations, as you said, Ms. Anderson?
Those are correct, Your Honor.
All right, now, just for the record, it's all pretty well been covered by Ms. Anderson, but just for the record, I'm going to go through your plea documents, Mr. Tucker, that you've signed or signed and sworn to in 241047220 and in 241047320. First one's going up on the screen will be your plea agreements, which are the same, and as we've already gone over in each cause number, 20 years in the Texas Department of Corrections Institutional Division. They would run concurrent at the same time with credit for time served. And on each set of plea papers for each cause number, you've signed an acknowledgement of admonishments. It has 5 admonishments. You and Mr. Davis have signed below the 5th one. On each, and these are all in each set of plea papers. You've waived and given up your right to a trial by jury in both cases. Do you understand that, Mr. Tucker?
Yes.
You signed what you have all these plea documents in both cases. You signed waivers of confrontation and agreements to stipulate testimony. Do you understand those plea documents?
Yes.
In each cause number, Mr. Tucker, for the offense now charged in the indictment, in each cause number, you have signed and sworn to stipulations of evidence. They'll be going up on the screen. The stipulations of evidence signed and sworn to by you. Do you understand in each cause number, the stipulations of evidence, stage 2, those are written judicial confessions under oath by you to the allegation and the charge in each indictment as it now stands. Do you understand that?
Yes.
Did you sign and swear to each one of the stipulations of evidence in each cause number of your own free will and sign each one freely, intelligently, knowingly, and voluntarily?
Yes.
The court does approve the stipulations of evidence signed and sworn to by the defendant, signed by his attorney in each cause number, stage 2, is approved by the court. Then you have agreements to stipulate testimony in each cause number. You've waived, given up your right to appeal, and waived, given up your right to file a motion for new trial in each cause number. Do you understand that, Mr. Tucker?
Yes.
You've also waived a pre-sentence in each cause number. Now, all these plea documents in both cause numbers, you have signed all of them. Certain ones of them that I've indicated are now signed and sworn to. Do you understand all the plea documents you've signed or signed and sworn to in both these cause numbers?
Yes.
Do you understand your plea agreements that I've been over with you in both cause numbers? You'll be assessed a sentence by the court following the plea agreements of 20 years in the Texas Department of Corrections Institutional Division. They'll run concurrent or at the same time with credit for time served. Do you understand those are your plea agreements?
Yes.
Do you have any questions for the court about anything that we've been over so far?
No, I was just looking at some of the paperwork and I seen that the punishment range was assessed to 5 to 99 from what I first seen, from what I understood, it was 15 to 99. So that's why I pled to 20. I didn't know that it could have went below that, but what's done is done, I guess.
Your Honor, just for the record, we've been over this, but just for the record, the only reason it's gone to 5 to life is just because the state it's part of the plea agreement, Judge. Otherwise, if it went to trial or anything like that, obviously it would still be 15 to life. It's part of the plea agreement. So That's the range on there.
And that's correct, Your Honor. We only made those motions on the indictment and the changes that we did because the defendant agreed to plead guilty today.
Okay, so the bottom line, what I need to know from you, Mr. Tucker, are these your plea agreements?
Yes, they are.
And do you understand the plea agreements as they stand today?
I do now, yes.
All right, of course, you've noted and you've heard as part of your plea agreement, each indictment alleged that you used or exhibited a deadly weapon is charged in the indictment. Now, those second paragraphs, which is part of your plea agreement, the state elected to waive and abandon those two paragraphs in each indictment that alleged you used or exhibited a deadly weapon as part of your plea agreement. Had the state pursued those allegations that you used or exhibited a deadly weapon in each paragraph, and either you stipulated to it or the court proved it, these would be half-time offenses, so that any sentence you receive, either in a plea agreement or from a jury, you'd have to do half of it day per day.
I understand.
Do you understand the benefits you got from
Oh,
the
I do.
state? Well, okay. I just want to be sure you understand, because that's the major change here, is that once the state waived those allegations you used or exhibited a deadly weapon, then it came off the mandatory half-time category. You with me on that one?
I do.
All right. Do you have any other questions for me?
No, sir.
All right, you do understand all the allegations, the charge in each indictment, all these plea documents you signed or signed and sworn to in each case, and your plea agreements, is that correct?
Yes.
And you still do wish to go forward and enter a plea of guilty to the charge in the indictment and each cause number without a jury, is that correct?
Yes, sir.
All right, all these questions I'm asking you are for the purposes of your pleas in both cases. Do you read, write, and understand English?
I do.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No.
Do you understand everything you're doing in court today?
I do.
Have you been over everything you're doing in court today on both these cases and the facts of both cases with your attorney, Mr. Davis?
Yes.
Is he competent, Mr. Davis?
Yes, Your Honor.
Any else in comments, Ms. Anderson?
No, Your Honor.
No State's counsel signed his consent to approve the waiver, her consent and approval of the waiver of trial by jury. Court approves the waivers of trial by jury and all the other waivers in both cases signed or signed sworn to by the defendant, signed by his attorney. All right, now for purposes of your pleas, Mr. Tucker, do you understand all the allegations and the charge against you in each indictment?
I do.
Do you understand the full range of sentencing for each indictment and the recommendations in your plea agreements?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
All right, in cause number 241-0472-20, what is your plea today to the indictment in that cause number charging you with the offense of burglary of a habitation enhanced to a first-degree felony?
Guilty.
In cause number 241-0473-20, what is your plea today to the indictment charging you with the offense of impersonating a public servant, a third-degree felony, enhanced to a second-degree felony?
Guilty.
Are you entering your pleas of guilty to the indictments in each cause number today because you are guilty and for no other reason?
I am guilty.
Has anyone threatened you in any way, coerced you, or made you plead guilty in either case?
No.
Are you entering your plea of guilty to the indictment in each cause number today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you by the indictment in each cause number?
That's correct.
Are you entering your plea of guilty to the indictment in either cause number today because you have any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No.
All right, the court does receive and accept your plea of guilty to the indictment in each cause number. Okay, Ms. Anderson.
Your Honor, in each cause number, we offer States 1, the plea packet with signed waivers and admonishments, States 2, the signed and sworn stipulation of evidence, as well as States 3, the discovery compliance documents.
No objection.
With no objection in each cause number, States Exhibits 1, 2, and 3. State Exhibit 1 being all the plea documents in both cases. States 2, the signed and sworn to stipulations of evidence. the written judicial confessions by the defendant under oath to the allegations in the indictments as amended, both proved by the court. And then stage 3, discovery compliance proved by the court. Court admits into evidence in each cause number without objection, states exhibits 1, 2, and 3, signed or signed as sworn to by the defendant, signed by his attorney, signed by state's attorney. Any legal reason to bar formal sentence in either one of these cause numbers, Mr. Davis? The court's going to
No, Your Honor.
The court's going to receive and accept the defendant's plea of guilty to the offense alleged against him by the indictment. Each cause number as it now stands. Court having admitted into evidence the plea, all the plea documents in both cause numbers. The court receiving the defendant's plea of guilty to the offense of burglary of a habitation, second-degree felony enhanced to a first-degree felony in cause number 2410472-20. The court does follow the plea agreement, having found the defendant guilty on his plea of guilty to the offense of burglary of a habitation, second degree enhanced to a first degree. Court follows the plea agreement and assesses the sentence at 20 years in the Texas Department of Corrections Institutional Division over in cause number 241-0473-20, offense charging and impersonating a public servant. Court receives and accepts the defendant's plea of guilty to the offense alleged in this cause number, impersonating a public servant, in 241-0473-20, third degree enhanced to a second degree. Court follows the plea agreement, assesses the sentence at 20 years in the Texas Department of Corrections Institutional Division. No fines, assessed, court costs ordered paid. Restitution order is due in each cause number. Credit for time served granted on the sentence assessed at each cause number. Both pleas having been done in the same hearing. The 20-year sentence assessed by the court following the plea agreements in both cause numbers. Each 20-year sentence is ordered to run concurrent at the same time with the other 20-year sentence with credit for time served. The court, in no reason bar formal sentencing, I think we're down to that now, Mr. Davis.
No, sir.
Finding none, the court does formally pronounce the sentence in each cause number follows the plea agreements or recommendations of the state, having received and accepted the defendant's plea of guilty to the indictments as amended, as stated into the record by the court, reflected by the plea agreements. The court does assess the sentence of 20 years in cause number 241-0472-20 for the offense of burglary of habitation. The court assesses the sentence of 20 years in cause number 241-0473-20 for the offense of impersonating public servant, both as alleged in the indictment enhanced. Those sentences, 20 years, the Texas Department of Corrections Institutional credit for time served ordered to run concurrent at the same time. Waivers of appeal and waivers of right to file a motion for new trial accepted and approved. Order filed in the papers of the cause by the court in both cause numbers. Mr. Tucker, your court-appointed attorney, Mr. Zach Davis, who's represented you in both these cause numbers, are you satisfied with Mr. Zach Davis' legal representation?
I am.
It'll be the order of the court then, Mr. Tucker, you'll be continued in the custody of the sheriff until you can be transported to the Texas Department of Corrections Institutional Division to serve the 20-year sentence assessed by the court with credit for time served for burglary of habitation as alleged in cause number 241-0472-20, and until you can be transported to the Texas Department of Corrections Institutional Division to serve the sentence of 20 years with credit for time served for the offense of impersonating a public servant alleged in the indictment 241-0473-20. As stated by the court multiple times. Each 20-year sentence is ordered to run concurrency at the same time as the other 20-year sentence with credit for time served. Waivers of appeal, waivers of right to file a motion for new trial, received, accepted, approved by the court. Anything else, Ms. Anderson?
Yes, Your Honor, just the state would offer for purposes of sentencing states for a single copy, a single electronic copy of the written discovery in this case.
No objection.
We had no objection. States for, thank you, Ms. Anderson. States for all the written discovery are on desk and each cause number is admitted into evidence with no objection. If there's nothing else, sentence has been formally pronounced. Defendant continued in custody of the sheriff until he can be transported to TDC to serve the sentences as stated multiple times by the court. If there's nothing further, we'll be in recess on this case. Defendant's continued in custody.
Should just have Scott Davis left. That's a reset, but he's not there yet.
This is just for announcement purposes only from jail by Zoom. State Defense Counsel present, defendant Scott Davis present before the court. Cause number 2410925-20. That would be an indictment pending against the defendant for manufacturing and delivery of a controlled substance as alleged in the first paragraph in an amount of 200 grams or more, but less than 400 grams, including any adults or diluted. Second paragraph alleges a prior felony conviction for the offense of possession of a controlled substance. Third paragraph alleges another prior felony conviction for the offense of possession of a controlled substance over in Gregg County. All right, we're here apparently for announcements today with the defendant present, everyone, the state's counsel, Ms. Anderson, Mr. Davis, defense attorney, all present by Zoom. Of course, if the enhancement paragraphs were proven in this indictment, it would be enhanced up to a first-degree felony. Go ahead, Ms. Anderson.
Your Honor, the state and the defense have actually reached an agreement for 35 years in this case with 1245 consideration of some other unfiled cases. Unfortunately, due to shuffling around, I believe the paperwork was lost at the jail and it did not make it over here in time this morning for the hearing. So we're going to extend the plea deadline just to allow Mr. Davis and his client to either re-sign that paperwork and submit it or find the lost paperwork at the jail.
That's fine, Ms. Anderson. We had a date a few minutes ago when Mr. Davis was going to be back on some pleas, and we set a, what was that date, Denise?
September 14th at 1:30.
September 14th at 1:30. Is that satisfactory?
The state will be there.
All right, with the agreement of the state and defense, September 14th. Is that a Monday, Denise?
Yes.
Monday, September the 14th at 1:30. Will be back from the jail. Defendants continued in custody on Zoom on both these cases to take what appears to be a plea agreement that's now been reached. It's just a matter of getting the plea papers. The court doesn't have the original plea documents yet. It's not anyone's fault. It just happens as many cases as we do. So we'll reset it for two purposes: to take the plea on September the 14th, Monday, September 14th at 1:30. The court's going to follow the plea agreements, assess the sentence as recommended by the state, agreed to by the defendant and his attorney. At the same time, in this case, as in others, now the plea deadline is September the 14th at 1:30. And I understand there's already been plea agreements reached, but if for some reason it didn't go through, if like the defendant changed his mind for some reason on September the 14th and the plea didn't go through for some reason, then that would be the plea deadline. The court would not accept this plea after that date. So we're in recess until that date to take the agreed plea in this case once the court gets the papers, but that is the plea deadline. Anything else, Ms. Anderson?
No, Your Honor.
After all of that, anything else, Mr. Davis?
Not today, Judge. Thank you.
We are in recess on this case until September the 14th, Monday, September 14th at 1:30. Defendants continued in custody until that date when apparently we'll be conducting the actual plea. We're in recess.
Your Honor, I believe that we have concluded our morning docket. May the state be excused until 1:15 today.
Yes, Ms. Anderson, thank you very much. Thank you. We're in recess till 1:15. Apparently that seems to be the call. Are you back then, Mr. Davis, or are you done?
No, Judge, that's all I have for today. We'll get that plea paperwork straightened out. It looked like Mr. Davis had gotten it at the jail just this morning, so we'll get it filled out.
But whatever it is, I'll take the plea. It follows Ms. Anderson's recommendation. Just a matter of